Namaste viewers, welcome to another episode of the Indian Lawyer Legal Tips. Today with us we have an expert, Mrs. Sushila Varma, Chief Consultant, the Indian Lawyer and AlliedServices. Welcome ma'am.
Thank you, Harini. Namaste, viewers. It's indeed a pleasure for me to be doing one more episode at the Indian Lawyer Legal Tips.
So to begin with, in today's episode, we are going to discuss the importance of evidence in a court of law. So we all know that when a court decides a matter, it's based on evidence. It's not what we know, but what we can prove in a court of law decides the fate of the case. So to begin with our today's session, my first question to you ma'am would be, what is the significance of an evidence?
This is a good question, Harini, because most people who are litigating in court have no idea about the importance of evidence. Evidence is the medium through which the court is convinced of the truth or otherwise of the matter, and which helps the judge to finally decide whether your case is supported by the truth of the statements that you are making, or you have failed to prove what you are trying to say.
So, ma'am, now that we know the significance of evidence, while proving a case, what is considered actually to be an evidence?
Evidence can be in several forms, Harini. It could be the words of witnesses, it could be material objects by which you can prove a point, it could be documents, it could be electronic records, it could be admission of parties, or it could even be the report of a local inspector or a commissioner. It could be statements made by witnesses on affidavit or otherwise, and it could also be answers that are given during cross-examination. It's very difficult to have a restricted answer to what is evidence. Evidence is essentially anything by which you can prove your case.
So, ma'am, that seems to be quite an exhaustive list. Now, if you could please explain to our viewers what could possibly be the types of evidence also?
Yes, Harini, primarily there are two types of evidence. One is the oral evidence and one is the documentary evidence. Now, even oral evidence, Harini, is of two types. One is the original or direct evidence, that is the evidence which is given by a witness, where a witness himself or herself reports a certain aspect of the case. Whereas there is another type of evidence which is known as hearsay evidence. An evidence which is like a second-hand evidence, in which a witness is reporting not what he himself has seen, or rather it is what he has learned about a fact through some other means, like a third person. Now, we must also understand that there are two other aspects of evidence, which is what is known as primary evidence and secondary evidence. Primary evidence is an oral account of the original or direct evidence of a person who saw what has happened and gives an account of what he has seen. Or if it's a document, it's a statement about the document itself. Now, secondary evidence is a report or an oral account to prove the contents of the original evidence. For instance, it could be a copy of a document that has been shown as primary evidence.
So, ma'am, now that we know that there are various categories of oral evidence, could you also please explain to our viewers what could possibly be a documentary evidence also?
Yes. Harini, one thing I want to tell the viewers over here, documentary evidence is by far the most important type of evidence that a client or a litigant can produce before the court, because documentary evidence is always at a higher level as compared to oral evidence. Documentary evidence would mean all documents by which you could prove your case. It could either be physical documents or electronic records. Now, documentary evidence has, when you are using documentary evidence, you have to produce the original so that the document can be compared and it is a primary evidence.
So far we have learnt about oral evidence and documentary evidence. So ma'am, we have also heard about circumstantial evidence. Could you please elaborate on this subject?
Circumstantial evidence is an indirect type of evidence. It is an evidence by which a logical inference can be drawn about a fact, either conclusively or presumptively. Now, facts that show the existence of any state of mind, such as the intention, the knowledge, the good faith, the negligence, or ill will, need not be proved by direct testimony of parties. It can be proved by inferring from the conduct of the parties. So, this is one of the instances of circumstantial evidence. Another type of circumstantial evidence would be documents or objects received in evidence from which the existence of a fact or an issue can be inferred. Again, forensic procedure could also be another instance of circumstantial evidence.
Thank you ma'am. If you could also explain to our viewers as to how does one prove a case?
Proving a case is the most difficult part of a case. That is where the expertise of a lawyer comes. Now, a lawyer can also prove a case only depending on the evidence. Now, what would constitute evidence? First, I would say would be the statement of witnesses. This can be examination in chief, cross-examination, and in some cases re-examination. Then you will have examination of the documentary evidence. After this, you also have to look at admission made by parties. Now, admission of documents can also sometimes be used as circumstantial evidence. In a criminal case, the prosecution has to discharge the burden of a greater degree in proof, because in a criminal case, you have to prove that the person accused is guilty beyond all reasonable doubt. The presumption is therefore that the accused is innocent till he is proven guilty. Now, there are certain acts such as the Dowry Prohibition Act 1961, the Protection of Children from Sexual Offences Act 2012, where the burden of proof shifts on the accused. So, what happens in these kind of laws is that the accused has to prove he is innocent rather than the prosecution trying to prove that he is guilty.
Primary evidence and secondary evidence in our previous question. If you could please elaborate a little more as to when can a person rely on secondary evidence?
Yes. Essentially, primary evidence is the evidence by which you can prove a case. But many a times that primary evidence is not available. For instance, if the document is lost. Now, in such a case, in the interest of justice, the court can allow you to use secondary evidence. That is, a person can come and try to give evidence orally that he saw the document, or it could be a copy of the document which is produced before the court, and an affidavit is given that the original is unavailable. Now, when it comes to secondary evidence, there are certain types of documents that can be used as secondary evidence, namely certified copies, copies made from the original by a mechanical process, for instance photocopying, then copies made from or compared with the original, then it could be counterparts of documents as against the parties who did not execute them. It could also be oral accounts of contents of a document given by some person who has seen it, or it could be an oral admission about the document, or it could be a written admission about the document. Lastly, it could be evidence of a person who has examined the document, the original of which consists of numerous copies, all of which cannot be bought before the court of law, and hence the person is giving his statement that the document exists, but because it is not possible to bring it to court, he is giving evidence of the same.
Thank you so much, ma'am. So, ma'am, you were talking about admitted facts earlier. If you could please explain as to what happens when there is an admission.
Yes. Now, this is again another very important aspect of a case in court. Now, if a party has admitted a particular fact or a document, then it is deemed that that particular fact or document does not need to be proved. However, it is still left to the discretion of the court to decide whether they will accept the admission or they will direct the party to prove such admitted facts. Further, admission is not always conclusive proof of the matter which is admitted. Certainly, it's a good evidence and it binds the person who has made the evidence. So, but there are times that there can be a mistake, and in such a case, if you go to the court and say that I admitted a particular document or I admitted a particular fact under a mistake, then the court can ask you to be examined as a witness and can decide otherwise.
Ma'am, what is the veracity of an oral evidence?
Well, oral evidence is certainly important, but the law of evidence requires that only the person who has actually perceived something or was physically present at the crime scene should make a statement to that effect. Not anybody can come and give oral evidence on a particular fact.
So, ma'am, we've also heard about a dying declaration in the media and newspapers. So, if you could please explain to us what this concept is all about.
Well, a dying declaration is something which is a very, very critical piece of evidence. Essentially, a dying declaration means a statement is made by a person who is in the throes of death. That is, he is about to die and he decides that he will make a statement. Now, not any statement will be deemed to be a dying declaration. A dying declaration, because it's such a crucial piece of evidence, has to be recorded in a manner that is essential and that is recognized by a court of law. So, in a dying declaration in a criminal matter, a magistrate has to be present at the time of recording of the evidence. Now, insofar as dying declaration is concerned, there is a very important case called Bhajju versus State of MP, 2012. In this particular case, the person dying had given a dying declaration. The Supreme Court, after going through the case, was of the opinion that if a dying declaration has been recorded in accordance with law, only then it is deemed to be reliable and can be given and can be considered to give a cogent and possible explanation on the occurrence of the facts. But in the event that it has not been done in such circumstances where it is deemed to be reliable, then a court is not bound to accept the dying declaration.
Thank you so much, ma'am. Now that we know the significance of evidence in a court of law, what could possibly be the consequences if one is not able to provide evidence?
Well, the obvious answer is that the person will lose the case, okay, and the case will get dismissed. Additionally, sometimes the court can grant benefit of doubt if you don't have enough evidence to prove. Suppose the prosecution doesn't have enough evidence to prove a particular crime. Sometimes the person who is accused can get the benefit of doubt. There are times that when the evidence of the prosecution is not sufficient, the accused can be acquitted. Then there are times that the case can be dismissed. Then also there are instances where the court has felt that the person who made the complaint has wasted the precious time of the court, and in such a case they can impose heavy costs. And most importantly, the person who has been accused of a particular crime also has the option of filing a defamation case against the complainant if the case that he has filed has been dismissed.
Thank you, ma'am. Could you please explain to our viewers any case law on evidence?
Yes, there is a case called Neeraj Datta versus the state. It's a 2023 case, and it has been decided by a bench of 5 judges. Now, in this particular case, what the court held was that in the absence of primary evidence, it is difficult for anyone to prove a bribery case. In this particular matter, the person who was accused of having being corrupt and taken bribe. But the primary evidence that was there was not enough to prove that he had taken the bribe. It is only the circumstantial evidence, because of which the court felt that it was not sufficient, and as such, the prosecution did not succeed in the allegations that they had made.
Thank you so much, ma'am, for today's session. Is there anything you would like to conclude?
Yes, I would like to tell all viewers that it is not very easy to go to a court of law and make any averment and prove your case. You must be very careful about the fact that you have the necessary evidence, and when we say evidence, you must ensure that you have documentary evidence to prove your case. If you fail to prove your case will be dismissed with cause. So, dear viewers, please do not go rushing to court to file cases which are meaningless. Ensure that whatever relief you are asking for, you have the evidence to prove your case.
Thank you so much, ma'am. Today was an enriching experience for me. I hope it was the same for the viewers as well. If you have liked this video, request you to please like, share and subscribe the video and circulate it as much as possible for a wider outreach. Thank you.
Dear viewers, evidence is one of the toughest subjects in the law. I would therefore caution you that whatever we've said is just the very general law. If you have any case in which you want to discuss the evidence, you have to go to a lawyer. You cannot base your decision on the basis of this particular legal tips. Thank you and namaste. See you in the next episode next week.